For latest updates, subscribe to our channel and press the bell icon.
So the first regulation which I'm going to talk about is the most popular and the most widely used regulations by the trade and the custom brokers insofar as it pertains to imports coming into India and the importers filing a document known as a bill of entry, which is necessary to file under section 46 of the Customs Act 1962. So whether you are clearing the goods, say for home consumption on payment of duty, or you are warehousing it, section 46 mandates that you must file a bill of entry under that section. So the regulation which I am going to discuss today is the bill of entry, electronic integrated declaration and paperless processing regulations 2018. There are 8 regulations in this particular regulation insofar as pertains to filing a bill of entry. As you may be aware that after the introduction of the risk management system RMS and filing of bill of entry online in the ICE gate of the Indian Customs. So a bill of entry is now known as a part of an integrated declaration which is filed by the importers subject to certain parameters, subject to certain procedures which have been mentioned as far as the ICE gate is concerned. So these regulations talk about when a bill of entry should be filed and what will be the late charge. I repeat the word late charge and not penalty in case it is not filed in time as per the regulations. For how long a bill of entry should be retained and what are the penalties, if any, one needs to pay in case you don't comply with the regulations which have been framed under the Customs Act. All regulations start with what is known as definitions, scope and extent, and accordingly regulation 2 talks about definitions. Under definitions, an authorized person will be the one who files a bill of entry under these regulations read with section 46, and it could be an importer or his agent or a custom broker or his employee who is authorized to file a bill of entry for the purpose of clearing the cargo either for home consumption or for warehousing. So this definition talks about emergence of a relationship between an importer who is the principal and the custom broker who is the agent. The second definition talks about the importance of a bill of entry or what is a bill of entry which has been accepted in the Indian Customs Electronic System or the ICES system and where a unique number has been generated for that particular bill of entry. The unique number generated talks about the number which remains static and does not change and also gives the identity that the importer of this particular bill of entry is the owner of the goods and has a document of title. These are the main important definitions in these regulations besides the other regulations such as ICE gate, IEC code and so on. Regulation 3 talks about the process by which a bill of entry has to be filed with the help of the digital signature on the ICE gate or the Indian Customs portal. Regulation 4 is one of the most important regulation as far as the filing of bill of entry is concerned. And this regulation, if not followed, can give rise to what is known as a late charge as mandated under section 46. As I said earlier, a late charge is not a penalty and is payable only in case the provisions of regulation 4 are not complied with. So let us now study what is regulation 4. Regulation 4 talks about when a bill of entry should be filed. In the Finance Act of 2021, these regulations underwent a change as compared to the previous scope under regulation 4. Let us now study what the current scope is as far as avoidance of late charge is concerned. At the same time, what is the statutory time given in filing the bill of entry? So, goods come into India in three distinct manners: by sea, by air, and by land customs station. That is by road. And for each of the three parameters of entry into India, the filing of bill of entry, the time limit for filing a bill of entry has been prescribed under Regulation 4. Let me start with a vessel. A vessel calling any seaport in India other than countries of Myanmar, Bangladesh, Maldives, Pakistan and Sri Lanka. The importer must file the bill of entry including holidays 1 day prior to the arrival of the vessel at the customs station. 1 day prior or before. Therefore, if a vessel is coming from UK, Felixstowe port, to say one of the ports in India, on a Monday, then the importer or his agent must file a bill of entry prior to its arrival at the customs station, including holidays. That means the importer, if required, has to file a bill of entry also on a Sunday. Otherwise, if he files the bill of entry on Monday, that is the arrival of the vessel, which is coming from UK, there will be a 1 day late charge of rupees 5,000. Now let us move ahead that if the vessel is coming from Myanmar, Maldives, Sri Lanka, Pakistan or Bangladesh, neighboring countries. In such cases, the importer must file a bill of entry by end of the day or before end of the day on which the vessel is calling from these 5 countries to any port in India, including holidays. Therefore, if a vessel is coming from Bangladesh to India, even on a Sunday, the importer must file a bill of entry by the end of the day on a Sunday. Otherwise, today, that is on Monday, he will be entitled to pay a late charge of rupees 5,000. This is as far as a vessel is concerned. Now let us talk about goods coming into India from an aircraft and at a land customs station. So when the flight arrives in India or a vehicle which comes to a land customs station, the provision says that a bill of entry must be filed before end of the day on which that particular conveyance, that is an aircraft or a vehicle, arrives at a land customs station, including holidays. That means if the vehicle is coming on a Sunday and the aircraft is also arriving on a Sunday, which is a holiday, the bill of entry must be filed before the end of the day. Otherwise, the next day there will be a late charge of rupees 5,000. This is the second part, what is enumerated in Regulation 4. The third part talks about when should a bill of entry be filed? When the goods arrive at an inland container depot or an air freight station. An inland container depot is an extension of a port and an air freight station is the extension of an airport as far as Indian customs is concerned, and the definition is covered under section 7. When the goods are arriving at an inland container depot, the importer or his agent must file the bill of entry 1 day prior to the container reaching that particular customs station at inland container depot, including holidays. So if a train is reaching, say, ICD Sabarmati in Ahmedabad on a Sunday, the bill of entry must be filed on a Saturday. Or if the train is reaching on a Monday, then the bill of entry must be filed on a Sunday, failing which there will be a late charge of rupees 5,000 in case the bill of entry is filed the next day. Exact procedure or exact regulations are also applicable to cargo going to an air freight station from an airport. That means if the cargo is moving from an airport to the air freight station, the bill of entry must be filed 1 day prior to the cargo reaching the air freight station, including holidays. These are the time limits which have been framed in Regulation 4 as far as the filing is concerned, so as to avoid the late charges. In the second proviso in Regulation 4 talks about the quantum of late charges. The quantum of late charges, as most of you may be aware, is rupees 5,000 per day for the first 3 days, and from the 4th day onwards till the filing it is rupees 10,000. However, the regulation also provides that the maximum late charge will not exceed the duty payable and will be up to or less than the duty payable. So in other words, the duty payable is say Indian rupees 2 lakhs and the late charge accrued are 3 lakhs, then the maximum late charge which can be taken will be rupees 2 lakhs and not 3 lakhs. Similarly, if the bill of entry is assessed duty free and there is no duty paid, then the maximum late charge which can be taken insofar as these regulations are concerned is rupees 50,000. So this is what is importance about the filing of the bill of entry in time, the accrual of late charges, and what is the maximum limit in which the late charge will be paid, and so on. Regulation 5 talks about how the assessment is done, and if examination is done, the auto charge has to be given in the customs automated system, and once the auto charge is done, the goods can be taken out of the CFS for delivery, and so on. Regulation 6 talks about that once the bill of entry is assessed to duty and custom auto charge is given, it must be retained either in electronic form or otherwise, that is hard copy, for at least 5 years from the date of out of charge, and all the other documents relied upon for clearance of the cargo must also be kept in hard copies for a period of 5 years and must be produced in case there are any investigations or any proceedings under this Act. Regulation 7 talks about that permission can be given in case an importer or his agent require an authenticated copy of a bill of entry, and on payment of prescribed fees, the same can be generated and given to the importer. The last regulation talks about penalty, and that is in case the importer or his agent contravenes any of the regulations, then he or she will be liable to penalty of rupees 50,000 rupees.
For detailed learning of all logistics subjects, visit www.logiveda.com.